Hello, hello. It is Monday, June 23rd at 8:30 p.m. Eastern Time. And it's been a few weeks since we've given an update on what's been happening with my family court case. We last went live on June 3rd, just before we went on a mini vacay, so to speak, in Naples, Florida area. So we have got a lot to explain because a lot's been happening. If you haven't already noticed from my hearing last week, they are working hard to try to break me by now taking my driver's license. So we want to get everyone caught up on what has been happening since we last spoke to everyone on June 3rd and kind of explain the craziness that is occurring at this point. And
some of this is, anybody who's dealt with any family court issues, you'll realize this is sort of normal in the course of family court. Anybody who's never dealt with family court issues, count yourself lucky, because the craziness and the lack of actual process and fairness is astounding. And I think if most people knew sort of what they get away with in family court, because it's really its own private little secret club that the judges get to control, and there's zero oversight.
No accountability. They just walk all over us, destroy us, and they grin and they smile as they're doing it.
So one of the things shortly after we made the last live video, literally the night before me and Heather are leaving town for a long weekend, Heather gets an email. Now, the context of this email, with everything going on down here in Florida, we're just trying to cover our bases, and one of those bases, we wanted to get a full certified copy of her family law docket from Illinois. Mm-hmm. So Heather filed a form, basically it's the equivalent to a Florida indigency form, to get the court in Illinois to send her the docket at no cost or free or a limited cost.
Thank you, Lexi.
Anyways,
love you.
So the night Heather filed the request on like Monday or Tuesday night. We were leaving here Thursday morning. Mm-hmm. Wednesday night, so like 24 hours. So must have been Tuesday night. It was 24 hours or less.
Why did I file for a fee waiver though? What were they quoting me for a certified copy of my Illinois docket?
Oh, it was like $400 or $500.
Yeah. When I called the clerk's office in Lake County, Illinois,
they never actually give you a price. They sort of say, well, it's probably this.
Right.
But you have to send them the exact amount.
But each document is $6 for the certified copy.
You have to send them
stamp.
A money order for the exact amount, plus return postage, plus return envelope.
Right.
Like it's the process is.
So being in Florida, if I wanted them to mail me a copy of my certified docket, they were basically quoting me $400 approximately. Now, if I physically flew to Waukegan, Illinois and went to the courthouse and picked it up, it would be a little bit less, but you add in the difference of flight versus postage and it equals out to be the same. So I had put in this fee waiver application to potentially waive that $300 fee.
Okay. Or at least get it reduced.
Right.
All right. So less than 24 hours after Heather files this.
2 hours.
Oh, I'm sorry. 2 hours after it gets filed.
I e-filed it into my Illinois docket, and 2 hours later I get
Heather gets an email from the Illinois Circuit 19 court, some judicial assistant. Hey, we need you to be on a Zoom with a judge at 9 a.m. tomorrow.
Very next day. So Thursday morning.
Okay. Now it's important to note, Heather has filed fee waivers in Illinois before. Mm-hmm. And for small claims cases and some other stuff that she's been through in the past. The process is there's 4 questions that the judge asks. They do the normal part, the process here we know. And the weird thing is Heather had called the clerk of the court office earlier to find out what the process was. She was told, well, you file this and then you wait, and when it gets approved for the next step, you contact the court and they'll tell you when the hearing is. Mm-hmm. That's the way it was explained by the clerk just hours before this.
And that's how it's always happened in the past when I was in Illinois.
So, and then you basically, we know you have to have a hearing in front of a judge. The judge is supposed to ask you four questions to determine if you are indigent, and then if they can move ahead with this. Okay. Well, that normal process is not what happened with Heather. So again, she gets this email 2 hours after filing. Hey, you need to be on a Zoom meeting with the judge at 9 a.m. Okay.
And then gives me the link.
So
bypasses the clerk, bypasses an actual notice of a hearing where it's on paper and
literally
documented.
That next morning, we already have travel plans. We had a 5-hour drive. So, but it was either do it then or Friday when we're at the hotel, and who knows if we'd have signal to be able to or anything like that. So Heather signs into the Zoom, which was 10 o'clock Eastern time, 9 o'clock Central. And I was not in the room when it first happened because the way Heather explained things to me, she was expecting it, asked 4 questions.
10 minutes tops.
And move on. Mm-hmm. Okay. That's not what happened. I, from the other room, hear Heather getting very frustrated, and it sounds like the conversation's going in circles. And I step into the room, and the judge is basically questioning why Heather needs these documents, to which Heather responded because she's got an active case in Florida that's directly related to this. Mm-hmm. And the judge was, well, you're asking the court to pay for all of this. And mind you, they didn't even have the price. The judge is hammering Heather on filing this fee waiver to get the docket.
Why do I need the documents?
Yet the court,
what am I going to do with them? Yeah. Why do I need a fee waiver? Why am I not working? Yeah. I mean, she was reaming into me.
It was not the standard 4 questions that Heather has been asked in the past. No. And then, so Heather had everybody's used Zoom. You can have the fake digital background. So Heather had a digital background because, there's no reason for people on the Zoom to see the rest of the room. Well, when Heather's getting upset, I came up to Heather, and I'm sort of just standing next to her, trying to help her stay calm. And then the judge says, is somebody else in the room with you? We need to know everybody in the room with you. This is a courtroom. Now,
mind you, I'm not in a normal courtroom Zoom where there's a bunch of other citizens. Yeah, I'm in a courtroom Zoom by myself with this judge. And this judge's name, for the record, is Judge Manek, M-A-N-A-K, of Illinois Circuit 19. I've never met her before, never seen her before, never heard her name before.
Heather's in a near full-blown panic attack, takes the blur off the screen, and tells the judge that, her fiance Pete is in the room with her. And then the judge starts questioning me. Like, what do I know about Heather's situation?
Now, were you put under oath before she started questioning you?
That's a very, very interesting question. I was not.
Neither was I.
Were you put under oath? No.
Nope.
They never had anybody swear in. So, so then the judge is questioning
very
me.
Arrogant.
And I was explaining to the judge, I'm fully supporting Heather. Right now, Heather hasn't worked since the car accident last year.
Manic, yeah.
We've got
Judge Manic. Yeah, she's definitely manic already.
Heather's on Medicaid. Been on food stamps in the past. Filed for food stamps again because a job that we had hoped was going to work out didn't. That's why she wasn't actively on food stamps.
Well, not only that, I just recently started 2 nonprofits and my LLC. So I've been really focusing on getting my personal nonprofit off the ground, Justice for the Serlick Children, to advocate for court reform and domestic violence survivors.
And the other thing is, we were doing okay as best we can, but by no means do we have tons of extra money just floating around like her ex's family seems to think.
Apparently, I'm loaded. I can afford $17.95 a month or $17.85 a month to pay my ex-husband, who is withholding my children from me.
$1,785.
Yeah, $1,785 a month is what I'm currently being ordered to pay Justin Serlick. Yet I have no income. and I haven't had income for over a year. And I have filed multiple child support modifications through Florida Circuit 7 and through Florida Department of Revenue, and they are refusing to modify my child support.
When the original order was issued, aside from the fact that it's jurisdictionally fraudulent, when it was originally issued, were you a full-time student?
Yes.
Are you still a full-time student?
Yes. Actually, I'm even
You're
more
a super student now.
I'm in my MBA and my certified paralegal program.
So anyways,
I'm a full-time student.
Not to get too hung up, because there's a lot more to cover. This hearing, it was,
bad.
It did not.
It was bad.
No proper service, no proper etiquette, no proper decorum from the court. And ultimately, It was very clear that someone don't get into that.
was trying to find information on what I'm doing with my Illinois docket. So Friday morning, after 40 minutes of being harassed by this Illinois judge,
something that should have taken 5 minutes tops,
was a 40-minute
more than
Zoom.
40 minutes, and it only ended because Heather just said the hell with it.
I had enough of her bullying me and putting me in a because she was literally bullying me. It was nothing short of bullying.
Heather was disconnected herself from the Zoom, and then 20-30 minutes later, Heather gets an email from the clerk saying, come back on to the Zoom. Heather responded, we're already in the car driving, we can't get back on. And then I think ultimately Heather responded with this email. Don't read the whole thing. I already posted it for everyone when it occurred on that Friday. What day was it? Friday the 13th. So I already screenshotted and posted the email. So I'm not going to read the whole thing because it's literally 3 pages, but it is quite literally me documenting exactly what this judge did to me in that hearing where no other citizens of Lake County, Illinois were witnessing this. And she absolutely is going to be slapped with a 42 USC 1983 along with everyone else in Illinois Circuit 19 when I get to that point. So this was me just documenting in an email that's submissible in court what she did to me and how she put me in a panic attack, and she needs to absolutely be investigated for the way she's treating people. She was the last thing I'll say about it is the way this judge was acting was as if this was her personal money. Okay, it was not. The U.S. Constitution ensures that every citizen has the right to access the courts. Okay, regardless of your income, regardless of your status. This judge was acting as an economic gatekeeper. To keep Heather out of the court, which is a direct violation of constitutional rights. Okay,
1983.
The judge should have done what every other judge in the past for a fee waiver has done: ask the requisite questions, document the answers, and it's a yes or no.
Right.
But that's not what happened. So
no, not at all. No, the way she treated me and singled me out in a individual Zoom is exactly how I was treated in 2020 in Illinois Circuit 19, 2021, and 2022 until everything transferred down to Florida. They would either verbally abuse me while I'm on permanent mute, so I can't even defend myself, while my public defender or my attorney stays silent and doesn't defend me at all. Or they just don't allow me to be in the Zooms at all, and I'm sitting in the waiting room the whole time, and they're making decisions about what's happening with my children, where they're going, and ultimately that's how they dumped them down in Daytona, Florida. So Illinois Circuit 19 is going to eventually, a lot of players in that courthouse in Waukegan, Illinois are going to be served with a 42 USC 83, 85, and 86. So that is where I'm at with Illinois.
And that's what those U.S. Code statutes Heather was calling in, or just stating, those are for civil rights violation.
Yes. Federal constitutional
and
civil rights.
Conspiracy.
1983 is specifically protection of your civil rights. 85 is when there's 2 or more people conspiring to violate your constitutional rights, which, I mean, there's way more than 2. There's probably at least 30 between Illinois and Florida now conspiring to violate my constitutional rights, keep my children from me, and force me to be an ATM to my rapist, who is withholding any and all contact between me and my children. I'm not his ATM. He needs to go away and be a father to his children and let me lead my own life. I am tired of being forced to pay my rapist that's withholding any and all contact. It is ransom. He is literally trying to collect ransom from me while he holds my children hostage. So let's shift gears to Florida. So we are on, since the June 3rd Facebook Live, I explained DIN 195. So now we're on DIN 196, and this is everything that's happened since the June 3rd. So there's a lot to explain. So DIN 196 is an order from Florida District 5 Appellate Court. I had originally filed in Circuit 7 a while ago now, a motion to stay child support pending the appeal. Because we all know, and I've explained this to everyone at this point, this April 27, 2022 order that's allowing Justin to hide my children from me because my rights are reserved in it, and then also ordering me to pay him $785 a month in child support, but it's not based on my financial affidavit or his financial affidavit. It's based on what Justin put on his financial affidavit in Illinois as expenditures for my children. $400 of that $785 is just entertainment and not providing me any receipts while I can't even see my kids. When that 2022 order was written, they no longer had jurisdiction. UCCJEA says wherever the children have been living for 6 months, that state is their home state and that state has jurisdiction.
And there's also a separate corresponding national law that all states have adopted specifically for child support enforcement. It's I can't remember the
UI
FSA.
Yeah, well, it's further in this
Uniform Family Support Act.
We'll get to it.
Anyways.
It's in these documents.
But according to both the UCCJEA and that, both of them, Illinois lack jurisdiction, and
therefore is void.
Is void. It's
void
not
ab initio.
It's not voidable. It is void.
It is. Yeah, there is a big difference, guys. Voidable is not the same as void. Void means it's just null. No one can enforce it. It should have never happened. It's void ab initio. Ab initio in Latin means from the beginning. From the moment it was signed, it was void. And according to UCCJEA, that's what makes it void. Yeah. But there's also other things. It wasn't properly registered in Florida.
Getting into the specifics between the two, it was not properly registered in Florida for child support enforcement. Mm-hmm. It was properly registered for the family law side of things in Florida. Just there's a specific statutory requirements for enforcement of a child support order that were not included when Heather registered it.
Right.
And Justin and his attorney, they did not register it.
No. So by that alone, Florida can't enforce it until it's properly registered, and it's not. So they can't enforce it at all. But so anyways, I filed this motion to stay child support pending appeal a while ago. Of course, Sandra C. Upchurch slapped it with a denial immediately. I then turned around and immediately filed a notice to appeal, got it right over to District 5 Appellate Court directly across the street in Daytona. And then I get a order from District 5 Appellate Court. We are going to view this as a standalone. So we would like you to do an amended motion for review of order denying motion to stay. So here I go again. I write up a whole new motion, amended motion for review of order denying motion to stay, filing in District 5, and then on June 4th, so this was one day after my last live, I get back ordered that appellant's amended motion for review of order denying motion to stay filed May 26th is granted as to review, meaning they're approving it for review. Upon review, the trial court's ordered a motion to stay child support pending appeal rendered May 19th is affirmed. So basically,
they're saying we're going to look at it. And we're just gonna let it stand.
Yeah. So they're not doing anything with it. So great. So I'm still continuing to rack up child support on this void order that they won't even allow me to modify. So that's wonderful. So that's where that's at. So DIN 197, order on petitioner's verified motion to vacate and refuse enforcement. So what is this?
All right.
This is what we couldn't talk about on June 3rd.
So, as we've learned more about the specifics about jurisdictional enforcement on child custody cases and the uniform code or the UCCJEA, Heather filed a motion to vacate. Now, it gets tricky because you have the order was issued by the Illinois Circuit 19. The case is now down here in Florida Circuit 7, but a void order is a void order, and it can be, attacked legally at any time. Okay,
should have been attacked a long time ago by my attorneys that I hired.
So Heather filed a motion with the circuit court here in Florida for the court here in Florida to vacate the
April 27th, 2022 order. That's literally allowing my ex-husband to hide my children from me. Okay. He has passed it out to all the schools in Volusia County schools. They're enforcing it illegally, so they're going to be slapped with a federal suit against me as well.
Okay. So basically we filed to get the Florida court to vacate basically deem the Illinois order void and to refuse enforcing the order for lack of jurisdiction.
And what did she come back with?
Adjudged and just denied.
Why did she deny it?
No specific reason.
No,
nothing.
Even though we all know it should be vacated. She knows it. Justin knows it. Mary knows it. Everyone knows it. This
is a common storyline we hear from a lot of other people in family court issues across the country, where judges just deny stuff and they don't give any legal reasoning,
no due process,
any valid justification. They just get to deny and then hope people just walk away. Well,
if someone files something this big, where it literally wipes out an entire order.
There was no hearing.
There should be a hearing.
At a minimum.
A minimum of a hearing should have been scheduled. And she didn't even schedule a hearing. It was literally just denied with no reason, no hearing, nothing.
So we did a little bit of research, and we'll get to that. Or we may not get to that today, but there's another step in the process, another action that we're going to be taking on that.
Yeah. So DIN 198, interestingly, this is June 10th at this point, so we're moving forward to June 10th. This is from the actual appeal department saying that Circuit 7 is filing a notice of late filing of record on appeal. So basically, when you get a notice of appeal, the tribunal court has a set amount of time to get your record sent over to the district appellate court. Well, this is literally Circuit 7 saying, oops, we effed up. We didn't send it in time. We'll have it, we were supposed to have it by June 9th, but we'll have it over by June 13th. So sorry. So yeah, that was interesting. And then DIN 199 is yet another notice of appeal that I filed, and that was on the denial of the April 27, 2022 Illinois order. So I get the Illinois order that's void, denied. I immediately turn around, file a notice of appeal to get it into appellant court. So this is them just receiving my notice of appeal, that I'm appealing that as well. Then 200 is another indigent form. 201 is something we should have probably filed a long time ago.
So we, again, some of the storylines you hear from other people in family court are, that the judges are, look, the judges in family court, now there may be one or two good ones across the country, but for the most part, judges don't aspire to be family court judges. These are essentially the bottom of the barrel, for people that want to be judges. And a lot of the time, from stories we've heard, is you have to hold their hand Okay, and we've actually gotten specific messages from other people who have dealt with Heather's judge, who literally say, like, the lawyers have to hold her hand through the court.
Like, I legit have had people from the Daytona area, when they hear my podcast or watch my YouTube videos, they now are reaching out to me. I have Upchurch as well. Here's the problem with her.
So since, you know, Heather files stuff and they don't even hold a hearing, how do you hold the judge's hand to make sure she understands the law, and how do you actually present the laws related to the situation to them? Well, there is something called a memorandum of law. Okay, so we prepared one. Memorandum of law on UCCJEA jurisdiction and loss of jurisdiction by Illinois. Okay,
so we're literally spelling it out in crayon for her.
So this is basically, this is not an actionable item on its own, but it documents for the court, and it's something the judge can look at. And we basically go through showing the Illinois statutes and the corresponding Florida statutes that are identical, by the way, because that's what the UCCJEA is. It's to get all of the states on the same page. But we basically go through, explain what the law is, how it's in the statutes for both states, what the jurisdictional standards are, how a state can lose jurisdiction even if a proceeding has started. Now, Heather's case is a little odd and unique because, yes, Heather started a family law case before everything blew up.
Yeah, and that's why
Illinois DCF stepped in. Now, with UCCJEA, anytime a custodial decision is made, okay, the next court that's going to make a custodial decision has to fully comply with all the standards of UCCJEA. In short, Heather starts her case in Illinois Juvenile Dependency Court through Illinois DCF sends the kids to Florida. That's a custodial decision. Mm-hmm. Once the kids are residents of Florida for 6 months,
it's Florida.
Illinois loses jurisdiction. Mm-hmm. Even if there's an open case, they have lost jurisdiction over those children who...
It's wherever the children are physically at for 6 months
Florida
or more.
is now their home state. Now, another little weird quirk in Heather's case, the Illinois docket seems to be incomplete. Seems to be things not in there.
Imagine that.
To initiate a custody proceeding, which is what would have to happen for the court to make a custody decision, there would have to be an initiation of a proceeding. You have to actually initiate it by filing a petition or a motion. Florida, they're called motions. Illinois, they're called petitions, but it's the same thing.
There's none.
There doesn't seem to be an actual filed petition.
And the reason we are saying this...
There's references to a petition in post-hearing order. So there was basically a hearing. The judge issued an order, basically instructions on what the parties were supposed to do after that hearing. So the only mention of it is in the February hearing. There's a mention that they scheduled an April hearing to hear this petition. But
there's no petition.
There's no petition. So, legally standing, when was the child custody action initiated? April 27th, when the actual court order was signed.
Mm-hmm. And I wasn't physically present for it. I had no representation, which means it should not have happened.
Illinois lost jurisdiction. Now, what are the implications of that? Well, first of all, as Heather has stated, the order is void from the start, meaning everything that's happened related to that order is
void,
wiped away once the court actually deems it void. The other thing that happens with UCCJEA, when a court violates UCCJEA, specifically when the judges do, or DCF, or really anybody involved, they lose judicial immunity. Okay. So, anyways, with I don't want to get too much sidetracked. With the memorandum of law, basically we're showing this is what the UCCJEA is. These are the statutes in Illinois. These are the statutes in Florida. This is how it applies to Heather's case. This is the actual case law. So these are other actual decided family cases through the regular court and appellate court across the country. These are how things have been decided here in Florida. And in conclusion, Illinois lost exclusive continuing jurisdiction under the UCC JEA when all parties relocated and the children resided in Florida for more than 6 months. So really, the moment when you actually dig into the very specifics, kids are sent. Justin's already in Florida. 3 youngest kids are sent to Florida. Kids are down here for 6 months. The moment Heather moved more than 25 miles outside the state of Illinois, Illinois lost jurisdiction. That happened in December of 2021.
Yeah. I officially got down here December 6th of 2021, about 3. So they physically were dropped off in Port Orange, Florida, August 13th, 2021. And I have an email from the caseworker to my attorney in Illinois confirming the kids were dropped off this morning, Port Orange, Florida, August 13th, 2021. I get down here in my RV August 6th of 2021 and set up shop.
December 6th.
December 6th of 2021 and set up shop. I'm trying to apply to state jobs. I'm trying to convert my driver's license, all that, because I am going to be wherever my children are. And if they wanted Illinois to continue filling out orders, maybe they shouldn't have moved my kids to Florida, because there is this UCC JEA exists for a reason. It keeps parents from hopping from state to state to state, either keeping the children from the other parent or to avoid child support. So 49 of the 50 states, Massachusetts being the only one that's not in it, have adopted this universal law to follow. So this does not happen.
And this law is interpreted not just amongst the states that have interpreted it, but if a foreign, out of country, so there's a lot of case law. There's a specific case here in Florida where a family custody case was actually started in Australia.
Yep.
And the parents had moved, or one of the parents had moved to Florida, and they tried to file a case in Florida, and it went to the appellate court, and the appellate court says, no, Australia, if you follow the UCC JEA guidelines, Australia is the home state. Australia has jurisdiction.
Yep.
So everything we've been digging through and coming across, related to UCC JEA, we're doing our due diligence. We're trying to find any sort of exceptions that would somehow allow Illinois to be deemed as still having jurisdiction. And we literally have not been coming up with anything.
And there's no way they didn't know.
Everything we run through the various systems, through multiple legal libraries, some other specialized software that we've got, general Google searches.
Oh, we've got a lot of resources now. We've got a lot more resources than we had a few months ago.
Yeah, everything kicks back the same response. Illinois lost jurisdiction once both parents moved out of Illinois and the children were, found another home state, which means they resided there for more than 6 months.
Right.
So, next.
Yeah. So DIN 202, because of that appeal, it's another one of my indigent forms. It's just constant, these indigent forms literally showing that I am broke and I have no money, yet now they're trying to take my driver's license. So then DIN 203, because of that notice of appeal for the April 27, 2022, it's instructions on my notice of appeal, which I've already got down pat. And then this is DIN 204. This is Circuit 7 telling me that they have sent over my record of appeal, late, mind you, but they sent it over. And then what's interesting about that is the very next thing is an order from appellant court stating that they combined my 2 cases. Now, a few lives ago, I had explained that I had 2 separate District 5 appellant cases going. 1056 was to address all of this insanity that Illinois caused with the 2022 order. And then my case 1442 is specifically for my disqualification of Judge Upchurch. And I wanted them to be separate for a reason. I don't want to be bogging down my briefs that are supposed to be focusing on my order with my children with the disqualification for the judge. But even though I sent them instructions to have them have the same record and travel together and not consolidate them, they consolidated them anyways. So DIN 205 is literally saying, we consolidated them and moving forward 1056. But what happened when they did that?
So when they consolidated them with appellate court, there's specific timelines between when certain things are done and when you have to file your initial brief. So you basically have 70 days to file your initial brief, or which is really it's due 10 days after your record is delivered.
Right. So
this
my original timeline, I had gotten my very first appeal into District 5 April 11th. So 70 days from then would be when my initial brief is due. So that would have been June 20th. But then this consolidation happened, and then all of a sudden I'm getting all these weird things from the courts. I actually got a call from the appeals department in DeLand, Florida for District 7 saying, because District 5 appellate court consolidated, we don't have to send over your record of appeal until like mid-July.
So we're just canceling the one that we already sent.
And I had no clue what was going on with that, so I had to do some digging. Yes. So DIN 206 is directions to the clerk on that void, the void order that I'm appealing. And then I noticed they messed up my docket, so I had to do an amended directions to clerk. So that's DIN 206 and 207. And then 208 is them confirming that they have received my appeal on the April 27, 2022 that she just denied with no reasoning, even though we all know it's void. And that started a brand new case in District 5 with that case number being 5D20251726. So I've got a 1056, a 1442, and a 1726. The 1442 was just merged into the 1056, so I don't reference the 1442 anymore. But now I've got two different cases, and I want this actually consolidated. So it's definitely getting, it feels like they're trying to play games with me because they're doing weird things.
I don't necessarily think the appellate court is actually playing games. I think it's just they have designed the entire process to be a game.
Yeah, well, it's a game of chess. That's what law is.
It is set up. It is set up
legal
so
chess.
That you miss one deadline and you've lost your shot.
Yep. Well, children's, livelihoods and their, health and, everything is on the line. So DIN 209, because of that consolidation and then getting a phone call from appeals department for District 7 saying they don't have to send it over until July, I'm like, well, what does that mean for my brief? So I filed a motion for clarification in District 5 appellate court saying, okay, well, this happened, then this happened, then this happened. Now appeals department is telling me they don't need to send it over till July. When is my initial brief due? So they then, DIN 209 is actually responding to me saying that the appellant is advised that the court's May 16, 2025 order told in all appellant deadlines until resolution of said order. The index shall be served on the parties by June 25th, and the record on appeal shall be transmitted by July 7th, and the initial brief shall be served by July 17th. So my initial brief went from June 20th to July 17th. So basically it was pushed a whole month. Because they consolidated two cases, I told them not to consolidate.
And we're expecting it to get pushed further because there's the third appeal.
There's the third one that I actually instructed them to consolidate. So all this is doing is pushing everything further down the road. I'm not getting any resolution on this void order. I have no contact with my children. I'm racking up this fake debt with my ex-husband that is my rapist. And that alone, I shouldn't be paying him anything for. He is my rapist. So now my initial brief is pushed a whole month, which it is what it is. I can't control it, but that's what happened. DIN 210 was filed into my case the morning of my hearing last week. Why don't you explain that?
So we're pretty sure this was the the attorney for the Department of Revenue filing it in, but it's basically just the official statement of child support arrearage, the way they've calculated it. And
what's the amount?
As of this, they're claiming $35,783.50.
$35,000 on this void order that Illinois signed
half of that,
outside of jurisdiction.
Half of that is attorney's fees. Half of that's not even actual child support.
May or may not. I don't know, because no one ever actually explained what all this debt is coming from. It was just served upon me with no due process. So basically, this is adding up from that $785 a month from the April 27, 2022 order that literally states, I'm not present, I have no attorney present to represent me. That alone is a violation of my constitutional rights, no due process. So that's the 5th and 14th Amendment. And then they also state on that 3-page order that I didn't give a financial affidavit. Why would I? February of 2022, Illinois ordered me to transfer the case to Florida because Florida had jurisdiction. So why would I give Illinois a financial affidavit at all? So that $785 was calculated from Justin's financial affidavit that he modified and added in expenditures to, and the $785 is adding up all those expenditures. So they're ordering me to pay my rapist $785 a month based on fictitious expenditures that he's spending on my 3 children while I have absolutely no access to them. Morgan v. Morgan states that if you do not have access to your children, you do not have to pay child support during that time frame that you do not have access to your children. Morgan v. Morgan, not Morgan and Morgan, the big law firm. Morgan versus Morgan, the case law, literally states that alone. So even if this Illinois order was legal and correct and not void, I still do not pay child support based on Morgan v. Morgan because Justin is withholding them from me because of child support. I have an email from my attorney clearly stating, I just got Justin on the phone. He said you can start seeing the kids again when you start paying him child support. That's not how it works in any state at all. That is literally illegal. So yeah, that was that whole situation. DIN 211 is another thing that I filed the morning of. I actually filed 3 things the morning of this hearing last Tuesday. And those 3 things, it actually got out of order. But the first one is objection to enforcement of unregistered foreign support order. Because remember, we also figured out that that order is not even properly registered. So here we are spelling it out for Judge Upchurch and the Department of Revenue that it's not even a properly registered order, therefore you can't enforce it, you can't take away my driver's license, and you can't force me to pay him. And then DIN 212,
And
2 minutes after that.
If the judge actually, the judge hasn't decided on any of this yet, but if she actually does decide properly on that one, that you're right, it's not properly registered, what that means is the whole entire contempt proceeding is void as well.
And then 2 minutes after that was e-filed, I filed motion to stay enforcement of driver's license suspension. So that's DIN 212. And then because it got out of order somehow, DIN 213 is the hearing and the hearing sheet. I'll explain that in a second. And then 215 is the third thing I filed a few moments after those other 2, right before the hearing on the 17th. And that is memorandum of law in opposition to enforcement of an unregistered or improperly registered foreign support order. So these 3 all go together. And I tried to read and explain and present these on Tuesday. And if you go back and watch that recording, the actual, I paid the $22 to get the actual digital court reporter's recording, you will see that Alan Holt, representing the Florida Department of Revenue, objected the moment I started speaking and then continued to keep talking over me so I couldn't present my evidence.
If you do watch that video, the very interesting thing is at some point Heather does get the bailiff to take these 3 things that Heather filed that morning and hand them to the Department of Revenue attorney, who then doesn't look at them at all, hands them off to the person sitting next to him,
Just watch the 15-minute video. You can see him
on in
literally
the
hand
hearing-
it to the other woman, doesn't even look at it.
Later on in the hearing, he claims to have reviewed the documents, but clearly he hasn't.
He obviously doesn't realize that we know how to pull court recordings and we can witness him not looking at it.
The hearing officer, who is not a judge, they're basically equivalent to a general magistrate, which they're just appointed to handle administrative issues and then make a report recommendation to a judge to sign. Well, he basically refused to acknowledge any of Heather's legal arguments. Now, this was specifically a hearing, if you look at the hearing notice, to address the
driver's license
Heather's
suspension.
objection to the suspending of her driver's license. Well, you would think you'd be able to present your legal your legal grounds for why you're objecting to this. Nope, they didn't want to hear that. They literally only wanted to hear if Heather has made any payments. And then at one point on the hearing, the hearing officer actually says, this is not a hearing to decide on your driver's license.
But it quite literally was.
Literally, that's the only thing it was.
In fact, my therapist, because I played that 15-minute hearing for my therapist last week, that was the first thing she noticed. She's like, did he just say you're not here for the suspension of your driver's license, but isn't that the reason for the hearing?
So then we ran the actual transcript through one of our legal analysis programs, and just asked it to give us an analysis of the hearing.
Just that hearing alone, I have a 1983 claim.
It literally, the first thing it came back was that there's significant due process issues because the hearing officer refused to allow you to present your legal arguments. Florida statutes require that the hearing officer hear any legal arguments. And if there is arguments or contesting of jurisdiction, the hearing officer is actually barred from issuing a final report. They're required to kick it back to the judge.
Yep.
Heather, what happened? He issued a report violating Florida statutes.
DIN 213 is his little report. And remember, all of these, like every other live, will be scanned and you can click on it and look through these. So, it's his little hearing report, and it says that my driver's license is not suspended upon payment of $1,000 within 30 days. This is not a purge. So they are basically forcing me to pay Justin another $1,000, because remember, he's already gotten $1,000 from the purge when they put handcuffs on me several months ago and tried to arrest me on a writ of bodily attachment. So he's gotten $1,000 on a void order from me already. Now they're ordering me to give him another $1,000 in 30 days, or they're going to suspend my license basically on July 17th.
And here's the
on a void order.
And here's what we're fully expecting. Even if we had the money to pay that, the following month,
they're just going to do this all over again.
They're just going to do it all over again.
And this is like, I don't understand where they think this money is going to come from. I am not working. I have not been working a normal W-2 job since March of 2024, because April of 2024, I was in a very severe car accident with a Corvette and 3 other vehicles. And I'm lucky to even be alive. So that took up most of 2024. I couldn't work because I was going in physical therapy and pain management treatments 3-4 times a week. So because of that, I decided to focus on my education, and I decided to launch my own LLC in marketing. So my Orbital Reach Marketing LLC, where I support other small businesses through social media marketing. And I also launched my nonprofit, Justice for the Serlick Children, to advocate for family court reform and advocate for domestic violence survivors and victims that have been pulled into this crazy system like my children and I have. And then I also have another nonprofit that is Southeast Volusia CERT, Community Emergency Response Team. So I have been very, very busy launching 2 nonprofits and an LLC while also being in school. I'm trying not to work a normal W-2 job anymore because I came from Chicago, where I was never qualified enough for corporate jobs. I come down here, I'm trying to get a corporate job, and every place I interview with, I'm overqualified and overeducated. So I'm done playing that game. I'm going to go into business for myself and create my own income and be my own boss. And apparently that's not good enough for everyone in this. They would much rather take my driver's license away and hurt me even more. So yeah, $1,000 in 30 days to Justin Serlick, who is keeping my children from me, or I lose my driver's license. And then DIN 214 is a copy of my information sheet I had to fill out before I went into that hearing last Tuesday with my address, my phone number, my height, my weight.
They force you to update your all your demographics.
And where's my place of employment?
Self-employed, Orbital Reach Marketing.
Self-employed. So apparently self-employed is not good enough for Circuit 7. They want me, on top of everything else I'm doing in my life, to also get a W-2 full-time job, to be an ATM for Justin, who is withholding my children, and my children have a 1.0 GPA and desperately need help. I'm getting quite tired of this. I'm not his ATM. DIN 215, Memorandum of Law in Opposition. So now we're getting back to that other one that was filed with the other two, but of course, the circuit clerks can't process things properly, so everything is out of order. So DIN 216, this is weird to me. This all of a sudden popped up in my case for a second time on June 18th. This was filed a while ago. This is a case trial exhibit storage report, so I'm guessing they're just saying, yeah, we recognize we got all of these exhibits proving that the Serlick children need help. Literally copies of police reports where I got through FOIA proof that my son attempted suicide in Justin's care, and Justin withheld that from everyone, including the courts. Pages of Volusia County schools showing my children's 1.0 GPAs consistently. 50 pages of photos proving that I have seen my son at school and he is always happy to see me, and that's Charlie Serlick at Palm Terrace. Photos of our home and the rooms that my kids will be living in, proving that we have a very nice home and are more than adequate of having my children to live here. Copies of emails Mary Serlick and Laura Stiles have emailed Pete and I, proving that they are quite literally
psychopaths,
mentally ill. There's no other word for them. They're just mentally ill. So this is literally proving all of the exhibits that I have filed into my docket, showing that my children desperately need help, and somehow it popped up in my docket again. DIN 217 is literally Judge Upchurch signing off on the child support hearing officer. Now I'm going to call him out by name. Neil Kaufman of Florida Circuit 7 Daytona Courthouse was my hearing officer. You can see him in the video that I posted, the 15-minute video from Tuesday, June 17th. So literally, she is ordering me to pay $1,000 on the child support case within 30 days, or my driver's license is suspended. An void order that she knows is a void order.
Void and improperly registered.
It's not properly registered, it's void. It's constitutionally void because anytime a judge signs off on an order that's violating anyone's constitutional rights, that also makes it void ab initio. So there's plenty of reasons for this order to not be enforced. DIN 218 is notice of timing discrepancy regarding memorandum of law and court order. So explain that.
All right. So we had no idea when the judge was actually planning on ruling on Heather's motion to vacate the April 27, 2022 order. Because it had been a while and just sitting there, we prepared the memorandum of law that we mentioned before and filed it. Then we noticed that the judge signed off on denying it the same day that we had filed that memorandum of law. So moving on to our next action, we just basically filed this notice that to just inform the court that we filed the memorandum of law and the judge may not have had access to that before she rendered her decision. So this sort of just is putting them on notice for the other motion that we filed sort of concurrent with that. which is basically
Petitioner's motion for written findings, clarification, and rehearing. Now, this is regarding the 2022 order. When I filed the motion to vacate and she denied, I got that notice from District 5. Well, I haven't explained that yet, but I got a notice from District 5 in regards to that appeal. So I'm like, okay, fine. We'll play this game.
So the judge, and this is common in family court systems across the country, they'll just deny motion and give no actual legal findings or reasoning. And so it just lets, it forces you, especially when you're pro se, to just sort of guess at what you're supposed to be doing. Because they've given you no instruction if they denied it because it was missing some technically statutorily required information, or if they're denying it just because they don't want to, or if they're denying it because there was some other actual legal basis. So we found in our as we're learning how to be lawyers basically that there's
crash course in being lawyer 101
in Florida statutes there and judicial rules and procedures. There is something you can file that basically forces the judge to explain their legal reasoning, and that is the petition for, or it's a motion for written findings and clarification, because we're not only just asking the judge to explain it, but we also had filed that memorandum of law the same day. We're basically we're asking her to explain herself, and by the way, please review that memorandum of law, and we're giving you a chance to fix this if you rehear. And now, granted, there was no actual hearing, but I guess rehearing in court terms would be the judge reevaluating her decision. So this is still pending in the court right now.
Yeah. But along with this, we filed a lot of exhibits. So Exhibit A is the memorandum saying, hey, we filed this the same day you denied it, so maybe you should look at it. And then Exhibit B is her denial, so that's in there. And then Exhibit C is the
actual copy of the order.
Yep, the whopping 3 pages that is completely wreaking havoc. Exhibit D is the email from Elizabeth Tevis to my attorney in Illinois confirming when my kids were physically dropped off at
establishing their
residency in Florida
for their Florida.
So we're basically once again spelling it out forward in crayon. This is why you need to deal with this. Exhibit E is the Uniform Child Custody Jurisdiction Enforcement Act affidavit,
which basically says, Heather's their mother. This is where the children resided at each different point in time. And
then Exhibit F, notice of timing discrepancy. So
which we filed separately and as a exhibit with this.
And so that's all of that. So that's still kind of sitting. We did just file it on Saturday, and it did just get e-filed officially into my docket this morning around 7:30 a.m. Yeah. So then today, we get this petitioner's motion to stay enforcement of driver's license suspension. I had filed that into my docket, and she came back and denied it today. But it
was interesting. This is like the first thing that there's been an actual reasoning on.
Right. So she actually explained, hey, you didn't serve the Florida Department of Revenue, which would be Alan Holt, so I'm denying it because you failed to comply with the aforementioned rules regarding service and certificate of service. So I just went back in my documented, added Florida Department of Revenue, added Alan Holt, and then e-filed it and served it to Alan Holt, and Justin will get another copy in the mail. But so that's that. But yeah, that has to do with my motion to stay enforcement of driver's license suspension, which I just e-filed today, so June 23rd. And it's literally saying, hey, you guys are enforcing a void order. And it's not registered. You're going to take away my driver's license, and it's all a void order.
And it's also violating Heather's constitutional right to access to the court.
You're violating my rights. You're violating my rights, guys. If you want to keep violating my rights, I'll see you in federal court with a 1983, 85, and 86. So, I mean, I don't know how much more I can spell this out. It's very obvious that I'm setting up my 1983, 85, and 86 case for federal court, because every single one of these motions now has its own section of constitutional violations. I highly recommend to all you victims out there, make sure you put in on all of your motions violations to your constitutional rights. Your First Amendment, your Fifth Amendment, your 14th Amendment. Make sure you're mentioning familials. Because
if you
don't,
the paper trail is what
exactly.
You want to
if
do.
you don't, and then all of a sudden you file in federal court on the 1983, that could very well screw up your 1983 because you weren't calling them out on those constitutional violations the whole time. So now everybody is getting called out on constitutional violations on every one of my motions. So when they get served by me at U.S. District Court in Orlando, they're not going to be surprised, because if they've read any of this, they would already know that I'm telling them you're violating my rights. So let's move to District 5. So like I said previously, they extended my initial brief due June 20th to July 17th. So that's one of the orders in my appellant case in my 1056. And then I had also filed, maybe about a week or two before my initial brief was due on June 20th, a motion for extension, because I wasn't sure if I was going to get the initial brief done in time, because as you can see, this is how crazy my case is. And it shouldn't be.
It almost seems like as you get one deadline, the court throws 3 or 4 other things at you to try to throw you off.
Oh yeah, this is absolutely intentional. This is absolutely intentional. And I can't wait to see these people in federal court. So this is actually a denial of my motion for extension of time, which is fine because they actually already gave me an extension. If this had been granted, I had only asked for 30 days. So I asked for this back on June 2nd, so that would have put me at July. So this consolidation that triggered the extension actually gave me more time. So fine, I'm okay with that. And then on the third appellant case, the 1726, that specifically deals with the April 27, 2022 motion to vacate that was denied and now moved into appellant court, it's been assigned case number 1726. On June 17th, District 5 Appellant Court sent me the following order. Ordered that appellant shall, within 10 days of the date hereof, show cause as to why this appeal should not be dismissed for lack of jurisdiction, inasmuch as it appears the order being appealed is a non-final, non-appealable order.
Now that's really
non-final.
That's really weird because Justin's attorney and the Department of Revenue and the judge,
they're all
Judge
treating
Warren,
it like it's
Judge
final.
Upchurch, and the general magistrate are basically all acting as if it is an absolute final order. So
I filed multiple modification requests, to which Florida Circuit 7 keeps coming back. You don't meet the requirements for a modification of the parental order.
Because for a modification, you have to hit the legal standard of a material and substantial change of circumstances. However,
I don't have to meet that.
If it's a non-final order, which it is because Heather's rights were reserved, not terminated.
Well, hang on. Not only were my rights reserved to the 3 younger children that were sent to Florida.
Both.
What about Ariana?
Both Justin and Heather's rights in that order were reserved as it goes for Ariana.
For my oldest daughter. And that alone makes it a non-final order, because that meant no one had permanent custody of her, and it had to be dealt with at a later time.
So even though the Illinois court ended their proceedings, they had to end their proceedings. They didn't have jurisdiction.
Which they should have just ended it then and said, hey, UCCJEA says we lost jurisdiction February 13th. We can't do anything else with this. You have to transfer it to Florida.
But that's not what happened.
Nope.
We know that. Anyways, we've actually subsequently come across, there's Florida statutes that literally directly address child custody orders and the word reserved. So that's, we'll see what happens with all of this, but then that's the next action that's going to come at some point.
Yeah. So obviously, I've been saying it very loud. I am absolutely going to be joining all the rest of the people across the nation that have had enough of this chaos, being kept illegally from their children, having their rights stomped all over like we're not even U.S. citizens. They are all starting or have already started federal cases against all of these bad actors. They are not immune like they seem to think they are.
There's no immunity from constitutional civil rights violations.
The moment they violate a U.S. citizen's constitutional rights, they lose that immunity. So
there's also no judicial immunity when they violate the UCCJEA.
Right. So that's where we're going with this, guys. I'm going to keep playing this game. I'm going to keep advocating for myself and my children. I'm going to keep fighting this fight. But in the meantime, I'm actually getting geared up. I've already got my federal complaint against Volusia County Schools pretty much written up. But now that they're trying to take my driver's license, this is pretty much the final straw for me. How dare they? How dare any of them think that taking my driver's license and making me a prisoner in my own home, basically they're putting me on house arrest, they think that this is okay. This is not okay. All of them know this is a void order. All of them know that Illinois should not have signed that order. They all are protecting a rapist and a child abuser, my ex-husband, Justin Serlick, and I don't understand why. He is nothing special in society. He smokes pot from the moment he wakes up to the moment he goes to bed. He plays video games. He doesn't even have an associate degree. He doesn't do anything with our children. Our children have 1.0 GPAs. They've lost their entire life. And it's just, at this point, I don't understand why they're continuing to protect him. The only thing I can imagine is that they are simply protecting themselves. And I'm done. I'm done playing their game. To federal court I go. So I hope everyone that's listening knows that you're not alone. We are all fighting this circus that is family court corruption together. We are all giving each other resources as far as softwares and sharing our knowledge with each other. This is the only way we are going to fight this illegal corruption in family court, is to band together, get this in federal court, get this in DC, educate our congressmen and women on what's happening, educate our governors on what's happening. It is very evident that this is the standard, and it is disgusting. My children deserve better. My children deserve to have a judge that protects them and doesn't enable their abuser. Everyone else's children deserves better. They deserve to be protected by the people that are elected or appointed to that position.
And really, from my perspective, as much of an outsider as I was before all of this, there's definitely a few things that would make immediate impacts on the family court system. First, everything is on the record. All hearings are recorded. All hearings have a court reporter. Once you put everything on the record, the judges will start acting differently. Two, you get rid of these third-party guardian ad litems and court psychologists, and you allow the children to actually testify. You make it on the record and put a kid testifying on what the kid wants, and it's on the record, 99% of the issues with family court get solved.
Instead, they have turned this into a racketeering scheme. It is absolutely RICO. Everyone is making money off of us as court victims. Everyone's making money off of the children, the parents, the attorneys. It's just all racketeering.
It's a multi-billion-dollar a year.
This racket needs to be investigated. And I don't know how much louder all of us victims can be. I demand an investigation. And on that, I am going to bid all of you adieu. We will start doing weekly updates to keep these shorter. We just had so much going on with our 4-day mini vacay.
We did have fun, and if you follow Heather's Facebook page, she did do a couple lives, just updates as we were floating around the lazy river, as well as on the on the bay, on the boat. So. Yeah.
So I will see everyone on social media. Stay strong. We are all in this together, and these bad actors are eventually going to find out that what they're doing is not okay. They already know what they're doing is not okay, but when we start exposing them to the public, because the public is paying their paycheck, I think they're going to see things a little differently. Okay. So have a great night, everyone. Thank you for listening. Thank you for your support, and I will see you next week. Bye.
Take care.